you're a software developer, and here you'd be developing software in connection with some medical application, think about the interface between the software and what you're trying to do medically. Focus on that. And be very careful about the words you use. And after Rashid's example of the claim with the screen printing limitations, that sort of thing is very easy to do in the software world. It's a area where I think, and there are no records kept in this area, but I think from experience the allowance rate is probably lower than average. There's a higher degree of scrutiny of what gets allowed in those arts. So yes, you can get software patents successfully, but you've got to have a strategy where you identify the elements that are going to be considered novel and identify the right language to use. I know that's kind of a rambling, non-specific answer, but I hope you get out of it is be very careful and get experienced counsel on that question. Don't look at a few patent applications and copy what others have done, because there's a lot of bad examples to follow out there.
By the way, there's this question about whether you can patent something that is just mental steps. I don't know if you're referring to that, and something more concrete like the graphs tree AAA. And that question right now is before the Supreme Court. So there's a case called In re Bilski, and the court should announce, it's one of the most highly anticipated decisions, at least in the patent world. And the court should announce it pretty soon. And that'll kind of set the standard for how far can we go in terms of patenting mental processes versus concrete things. So, that's up in the air a little bit, but we'll know pretty soon. So.
Go ahead.
I have two questions. One relates to the provisional application. How much new information or data you can generate, which turns out to be really a lot more than you had thought, and now you have a lot more to put it into your US or actual patent application. Can you do that, or you are just restricted to the provisional documentation of your invention, or you can use new additional material which you generated during that year? That's question one. And the second question is, you talk about claims, the lawyers, they dictate what can be said in a particular claim, and how does the scientist and the inventor go and say, no, I want this, and they say, no, you can't say this, so how do you deal with that part?
We don't like it when the scientists disagree with us. But it can be somewhat frustrating because the language and the pitfalls that you avoid as a patent attorney, you're trying to avoid certain problems by phrasing things a certain way, and the client may find that the language is unsatisfactory. I think you should be able to negotiate to mutually acceptable language through a process of communication. Certainly, if I have a client who's not satisfied with the claim language, I would very much want them to express that dissatisfaction to me so I could understand what the issues were and try to address them. In the end, you may end up with a claim that you don't like all that much, but you can at least agree serves its purpose and doesn't muck things up too much.
So I think that's really a great question. Let me talk about the second one first that John was also addressing. Obviously, the claim language, the specific form it takes, has to be determined by the attorney. They know, how it has to be put. There are certain legal requirements of antecedent basis, etc., that need to be there. So you need to meet all those requirements. But eventually, the claim is written in English, which you understand. And it's made up of all these limitations, A, B, C, D, E, F, whatever. The more the limitations, the worse it is. Okay, the way to avoid infringement is to knock out one of those limitations. So you got to remember this. And I really am an evangelist for having inventors be proactive and try to understand what patenting is. And if you're going to be a great innovator, you need to do that. So there are all these limitations. And if you can look at all those limitations, all those elements, and say, listen, you know, my invention is really just these three. Why do we don't need this 4, 5, and 6. In my example, the screen printing step was absolutely redundant. These, you know, unfortunately, the company that patented it was a big food company. Some in-house attorney like me, just handing it out to this outside attorney, never really communicated to them that the invention over here is just the screen casting of the edible sheet. So, and you know, even though there's legalese and all of that, but I think you have to take a little bit of responsibility and try to understand what your invention is and communicate it to the attorney that these are the elements of my invention, nothing more, nothing less. This is what it is. And that was a problem with the AAA patent too. Dr. White and you never communicated to the attorney that it's the overlapping which revolutionized treatment of AAA. They only talked about this self-expanding stuff and how it anchors and you know that kind of stuff, and that's what he wrote in the application. And then on the first question, that's a pretty simple answer. So you file a provisional, and if you develop more data between the time you file and the time you have to do your non-provisional, they all be included in the non-provisional when you convert it. So there's no, you're not limited to your initial disclosure. So you can add on to it.
So I think for the
Yeah, you know, your filing date for if there is prior art, etc. I mean, there are other things that come into it, but very often you supplement your disclosure with additional data.
So from the university standpoint, the most successful inventions are those in which the faculty really remain engaged and working with the officers and the patent attorney to develop the right application.
Dr. Rassman.
Can you discuss the limitations on processes that do not have apparatuses in medicine? Understand the question?
Yeah, you're on dangerous ground.
You like a new
We'll have to see
surgical
what Bill
procedure?
says.
Is that
Correct, yes.
like a new surgical procedure?
Yeah. Well, for any method that's not carried out using a machine or doesn't cause a transformation of some tangible subject matter, that is could be considered non-patentable subject matter. So for example, a diagnostic procedure, where all you're doing is running a test and then diagnosing a disease or condition based on that, on the test results. Well, under the way things are going, it looks like, although there hasn't been a clear-cut case on that, it looks like that's probably going to be considered non-patentable subject matter. Surgical procedures, because you're operating on a tangible patient, would be considered patentable because you're causing some change. Now there may be limitations on enforcing surgical methods, and Rajiv can probably speak to that better than I can.
So in terms of patenting a method of treating a surgical procedure, etc., they are patentable in the US. They're not patentable in Europe. So methods of treating human beings are just not, you cannot patent those methods in Europe. But you can patent them in the US. The problem with having a patent like that and enforcing it is that it's much better if my patent is infringed by Medtronic or Boston Scientific. Big bad guys, we can go and sue them. But your method, your surgical procedure will be infringed by Dr. Martin